Hello, everyone. Thanks for participating in our presentation today. A big thanks to the New York Grant Company for asking me to be part of their business education series. And what New York Grant Company does really is in line with what we do at SMA, which is mostly focusing on what I call outside-in immigration, so helping people with ideas, investment capital, or existing businesses to launch operations here as a platform for whatever dream they have here to do business in the US. So let's talk about the first path. This is the path that we use most here at SMA. We've presented E-2 visa petitions at over 50 US embassies and consulates. The most important concept here is the nationality of the company. And the nationality of the US company means the ownership. So 50% or more of the US company must be owned by foreign individuals or a foreign company from the same country, and only individuals from that same country can be sponsored under E-2. Substantial investment is the benchmark for how much should be committed. The number one question we get is how much is enough? What is the minimum? And by law, there is no such thing as a minimum investment. It really depends on the size and scope of the business, whether it's services and or goods, what those costs are for daily operations, plus the salaries to be paid to the person that's going to the US, as well as the projected hires, and that's over the course of an entire year. So whatever that might be, it could be 100,000, it could be 30 million. It depends on the size and scope of that business. So whatever you project for the first year operating costs should be what is invested into the US company. The office space that's secured must be big enough to cover the first year projected staff. And that means that virtual offices or virtual desks are not sufficient because you need to show a lease and you need to show a physical space with enough desks to cover the amount of people that you've projected to hire in the first year. Both under the E-2, a 5-year business plan is almost always required for the first petition. When you're renewing, most of the US embassies and consulates don't require, but you need that. And essentially, once you've shown that all the legal requirements are met, the final decision will be made based on the probability of success of the business, and that's measured more than anything by job creation. And that's going to be compared in the future when you go for renewals or for subsequent visa petitions to the numbers and projections that are in that business plan. So that is the primordial document in this process. One thing to keep in mind for E-2 is that there is no foreign entity requirement, which means hypothetically an individual with a concept and capital or investment from other sources, legal sources, could set up a US business on his or her own without having a foreign entity existing. The most important thing is the concept of benefits to the US. These visas are in existence to benefit the US economy. And so the marginality test is what's looked at here. And essentially that means that if only you as the applicant and your family members will benefit and no jobs will be created, then the business is considered marginal for the purposes of the E-2 petition and you will be denied. The more jobs that are created, the more potential you have for maximizing success of your applications. And in practice, not in the law, but in our practice over these 15 years, we've come up with a ratio of essentially 5-to-1 that you want to show that for each E-2 applicant or visa holder, there will be 5+ American jobs created. And that means either US citizens or green card holders. Lastly, we talk about the balancing between benefits and saving on taxes. And what I always say is that what's beneficial on an immigration level sometimes can be detrimental on a tax level, meaning you have to be willing to take the hit on taxes and to show that you are willing to pay them. If your entity is set up in a way where you're obviously going to minimize taxes at all costs to the expense of potentially generating more jobs, then that's going to make your case worse. There are two expressions I like to use that are very popular in the US. One is show me the money. The other is put your money where your mouth is. This has become inherently part of this process where you really have to show that number one, the investment is substantial. So if your projected cost for year one are 300,000 and you put up 250, they're not going to take it seriously. They want to see that you invested more than, or at least the same amount that you project for the first year costs. Secondly, the funds have to be committed. That means they need to stay there. That means they need to be in the US account when you apply. And then they must be at risk. And this is the part that's really escalated in practice over the last few years. They want to see that the company is real and operating, which means that the funds must already be being used by the investor and by the US company before you apply. So you have to be willing to take a real risk, which means contracting services, leasing an office space, paying for that office space, showing the first month's balance statement or the first bank statement, sorry, in order to show that the company is not only putting their funds at risk, but that it's real and operating. And if it's possible to hire staff before coming, that also is one very good way to do so. So let's talk about maintaining treaty nationality. This is tricky in these three specific scenarios. It's possible to do a joint venture. We had a case where there was an Italian and an Australian, they were clothing designers, and they wanted to launch a joint venture. We did two separate E-2 petitions for them based on their investment. They both invested in the business, and because they were from E-2 countries, they were both eligible. The issue becomes if they get offered any investment from outside investors in exchange for shares of the company, they have no margin of error, which means that they will no longer hold 50% of ownership. And that's very, very tricky. So essentially, the only way to maintain your E-2 status is if you always maintain at least 50% ownership. And if it's two 50% owners, then there's no flexibility whatsoever. Companies seeking venture capital have to also be very careful here, because it's possible to be a principal owner, to be a manager, an executive, or a founder, and get capital. We had an Italian client who got most of their funding in Silicon Valley from accelerators and not their own capital. But they had to find creative ways through their corporate agreements and corporate attorney to give up parts of their business without ceding more than 50% of their actual ownership. And that's something they have to maintain as long as they're here on that E-2 status. The last one, actually, we just had a very problematic situation arise where there was a foreign parent owner, which was a company, and that company, unbeknownst to the CEO, who was not a shareholder, sold 2/3 of its parent company shares to UK investors. This company was Dutch. So for the purposes of the E-2, the US company, since the ultimate owners became 67%, as opposed to before it was 100% Dutch, became 60% UK, the petition actually had to be withdrawn because the individual being sponsored was Dutch and not British. So it's very important that you maintain the ultimate ownership has to always be 50%. E-2 step by step, there are 80 countries that have E-2 treaties. There is a list that's published by Department of State, and essentially you can see right then and there what the E-2 countries are, which will help decide which track or which path to take. So the simple case would be a foreign national with a concept, company, or money, setting up the US entity, taking the preliminary steps, the sufficiently made investment to pass the substantiality test, securing the office, and moving the funds and starting to use them, and then applying at a US consulate or embassy, and then the visa would be granted. The maximum period for E-2 is 5 years by statute, but the Department of State reserves the right and can change at any time the maximum length that they give, or actually limit it down to even 3 months based on something called reciprocity, which we'll talk about. So it's important first to just determine which passports you have, who could potentially own the US entity if you're eligible for E-2 based on nationality. And then once you've done that, start putting all these into practice.